So thank you all for joining what is the final webinar in our employment series that we've been doing over the last 2 months. Today, as you can see on the screen, we're going to be discussing the two brand new statutes actually impacting employees at the federal level. Those, of course, are the Pregnant Workers Fairness Act as well as the PUMP Act. Both of these statutes have essentially homework for you HR professionals that are on the presentation today. There's new policies that are going to need to be enacted, new procedures you're going to have to follow, particularly under the Pregnant Workers Fairness Act, and a bunch of more hoops that we're now going to have to jump through as a result of these statutes. But of course, these statutes do provide new protections for pregnant employees, as well as those employees that are, pumping or still expressing breast milk for up to a year after giving birth. So we're going to go ahead and get started here today. Only planning for this presentation to go about a half hour, but if you have any questions or want to continue the discussion, I have no problem staying on after that. We're going to get started here with the Pregnant Workers Fairness Act. Again, this is a federal statute that went into effect just a couple months ago over the summer on June 23rd, 2023. Essentially, the Pregnant Workers Fairness Act requires that employers, and most of you on the phone today are going to qualify, have to provide reasonable accommodations to a worker's known limitations related to pregnancy, childbirth, or other similar medical condition. Essentially, the best and easiest way to be thinking about this in your mind as we go through the presentation is picture the ADA, the Americans with Disabilities Act, and that reasonable accommodation process you have to follow. It's going to be very similar to the Pregnant Workers Fairness Act, and that's the way I advise my clients as well, is when you're going through this process, just keep the ADA in mind, keep that process in mind, similar analysis, similar decisions to be made. So let's start with who is a covered employer. Again, as I said, most of you here on the phone today are going to qualify, but it's any entity that has at least 15 or more employees, regardless of whether it's a private entity or a public entity for you public employers that may be on the presentation. And I think it's important here to note that this statute will be primarily administered by the Equal Employment Opportunity Commission, otherwise known as the EEOC. They're the ones who are going to be responsible for implementing the regulations as those regulations change, as well as enforcing this. So investigating and doling out discipline to any employers that don't follow these requirements. I know many states have protections for pregnant employees. I can't think of any that really come to the top of my mind, except maybe California or New York, that provide protections to this extent that we now have under this federal statute. So some of you on the phone may have similar protections already in place, but for many of you, this is going to be a new thing that you're going to be required to issue and publish a new policy that's going to have to go out to your employees. Essentially, though, what are reasonable accommodations? Again, think about it like the ADA. Reasonable accommodations are changes to the work environment or the way things are usually done at work to allow the employee to continue to perform the essential functions of their position despite this pregnancy, related medical condition or childbirth condition. So examples of reasonable accommodations, obviously include the ability to sit and drink water, maybe park closer to the building, having some flexible hours. We just had a client who came to us and said, hey, we have an employee who is now pregnant. This new statute applies. Unfortunately, she's been going through, pretty extreme morning sickness and it tends to be really bad, especially in the morning. So she's requesting to be able to, start her day at 10 o'clock and we can even extend her shift. She approved that as well. So maybe she ends at 6 p.m. and they were fine with that. We put that into place. That was in place for as long as that employee needed those accommodations. Other examples, break time, additional break time for restroom visits, if they have to snack for blood sugar purposes, the ability to do that, or rest time if their condition requires that. We've also had situations where, in particular for this one client, safety devices needed to be resized, or they had to, otherwise purchase an additional harness that was of a larger size to accommodate a pregnant employee. Obviously, activity restrictions such as lifting or standing for certain periods of time. One aspect where this is going to differ a little bit from the ADA is when it comes to leave of absence. Many of you, in the presentation who've come to me before with an employee who needs to be out of the office as a result of a medical condition, but hey, FMLA is not applying, know that the ADA requires you to evaluate and consider and possibly implement a leave of absence as a reasonable accommodation for that employee. Under the Pregnant Workers Fairness Act, they're asking that a leave of absence be an absolute last resort, meaning no other possible accommodation could be made to allow this employee to work except a leave of absence. And at that point, you go through that process. But again, unlike the ADA, where you can kind of skip to a leave of absence, here it's a last resort for both the benefit of the employer and the employee. For the employer, it ensures that you're going to at least have one worker, even if it's on a part-time basis, working. For the employee, it means that they can earn some level of wages and stay qualified for health insurance. So it's the government looks at it as a benefit to both, likely probably more of a benefit to the employee, but still it ensures that an employee just can't come to you and say, well, hey, I need to be off until I give birth 9 months from now. Sorry, there's nothing you can do about it. You're now going to be able to go through that process to see if there's something else you can do rather than just putting that employee on a leave for 9 months. So are employers required to provide reasonable accommodations? So again, the answer is yes, similar to the ADA. The only exception would be if an undue hardship would be created. And we're going to briefly touch on what an undue hardship means. But, by and large, most of the conditions that are going to be exhibited by a pregnant employee could be accommodated throughout the day. Again, just maybe an extra 15-minute break or 2 extra 15-minute breaks. That's not going to be something that's likely to rise to the level of an undue hardship. And honestly, if you're at the point where you're evaluating whether an accommodation causes an undue hardship, that's the time you're really going to need to pick up the phone and call your attorney, pick up the phone, call me. So we can walk through that, because the defenses now we're starting to see, and we're seeing this nationwide. We covered it in a prior presentation. The EEOC and states, especially here in Ohio, are starting to crack down on employers just blanket denials of accommodations as a result of undue hardship. They actually want those undue hardships to be clearly analyzed and documented and decided upon. They truly need to be undue, and this really seems to be like a place that the EEOC is really starting to crack down, again, not only for the Pregnant Workers Fairness Act, but under the ADA as well. So what is an undue hardship? It is I have it in bold here because this is important, a significant difficulty or expense on the employer to implement that accommodation. It's obviously a very difficult standard to meet, one that needs to be documented. You need to show significant. We often get requests for just under the ADA, and I'm sure we might be seeing something like this as well for under the Pregnant Workers Fairness Act, but an employee will come and say, hey, I need to stand throughout the day, and I work at a desk and I have a chair. And I said, okay, well, we can accommodate you via a standing desk, but unfortunately these standing desks cost $500 or $250, whatever it may be. And it's really that, obviously, not scoffing at $250 to $500, but in the grand scheme of things, really kind of a nominal amount for a business. And they say, we can't make that accommodation, even though your doctor said this would benefit you. It causes an undue hardship. Meanwhile, that same employer flies their entire executive team to Europe for 2 weeks for executive training every year, and has lavish parties once a month at the office that they're expending funds on. So it's really at those point, the EEOC is really starting to dig into those cases and saying, well, hey, you spend all the money on these other things over here, but you can't spend $250 for this employee to have a standing desk. I'm not saying that's right or wrong, just saying that's really the reality of where the EEOC is at this point. You really never want to be in a situation, especially as a mid-sized, a large-sized company, where you're really arguing undue hardship as a result of expenses or additional cost. Now, there's 2 areas where the EEOC and the courts really agree that it would constitute an undue hardship, and that would be if you were required to hire an additional employee to help fill the duties that the existing employee can't perform. That's an area where the courts are saying, hey, you're not required to hire. You're also not really required to shift work from the employee requesting the accommodation to another employee. You don't have to make another employee do more work or have other added responsibilities, far and above what they normally do as a result of an accommodation. So those are 2 more concrete areas that if we can point to, we might be able to get you to that undue hardship. So what exactly does the Pregnant Workers Fairness Act prohibit? Covered employers cannot deny a job or other employment opportunity to a qualified employee or applicant based on that person's need for a reasonable accommodation. They can't require an employee to take a leave of absence, as we discussed, if another reasonable accommodation can be provided that would allow that employee to continue to work. They can't retaliate against anyone who requests an accommodation, or who opposes the failure to give an accommodation. That'd be seen as retaliation in the Pregnant Workers Fairness Act, and obviously just generally can't interfere with one's ability to seek an accommodation under the act. Now, you might be sitting there saying, well, hey, there's no protections in here for, you can't hire or fire someone just for being pregnant, right? Those protections aren't included under here. Those protections are already included in other statutes that have long since existed since the 70s at the federal level, and many states have similar statutes as well that prohibit denials to hire or fires or discipline as a result of an employee being pregnant. So those have already been protected. This statute's sole purpose is really just to allow employees who are pregnant to seek accommodations similar to the way they would under the ADA. Importantly here, though, unlike the ADA, being pregnant doesn't necessarily have to rise to the level of disability. And honestly, in most cases, looking to the ADA, a standard pregnancy without other complications, more severe complications, does not rise to the level of a disability. So what the federal government here is saying is, being pregnant by itself will allow you to seek potential protections in the form of accommodations under this federal statute, even if your pregnancy is not rising to the level of a disability. That's why they needed to add the second statute rather than just having everything fall under the ADA. So does the Pregnant Workers Fairness Act replace other protective laws? It does not. As I've indicated, a lot of states have already requirements that you can't engage in pregnancy discrimination generally, failure to hire or fire because they are pregnant. And a lot of courts, and you'll see here too, have looked at pregnancy, more lenient in terms of having it fall under the ADA in terms of accommodations and trying to get cases under the ADA. But what this does do is put that affirmative duty on an employer that they now have to go through that accommodation process, and they have to have a policy in place. Similar to how you have your ADA policy and your anti-discrimination policy in your handbook, you're going to have a policy for the Pregnant Workers Fairness Act as well. If you need help crafting that policy or are looking kind of for a form to base your policy off of, definitely give us a call. We can work through that, but you're going to have to implement that policy. So let's move on now to the second statute, federal statute that's in effect. And again, similar to the Pregnant Workers Fairness Act, this statute, brand new this year, will also require you to amend some of your existing policies to ensure that this is well highlighted and articulated in your handbooks. But the PUMP Act, otherwise known as its more lengthy term, the Providing Urgent Maternal Protections for Nursing Mothers Act, thankfully they shortened that one, grants most employees who are nursing the right to a reasonable break time and a private place other than a bathroom that is shielded from view to express breast milk at work for 1 year after the child's birth. That's really its basic summary. The important takeaway there is these protections last for a year after childbirth. Number two, they must be afforded a break time. We're going to get into whether that's a paid or unpaid break here in a moment. And the employer must provide a place at at their place of employment to express breast milk that is not a bathroom. You can't just designate a bathroom for this purpose. There has to be another area that's shielded from public view. I know some of our larger employers have brought in, kind of those pods that you see, at airports and other public places. They've purchased one of those pods to stick kind of in a more quiet area, but to have that designated place. Some people have designated an extra office that no one was using for that purpose. It doesn't have to necessarily always be this private location. That private location can change. If you don't have any pregnant employees, that office can be someone else's office. You can now reuse that office for another purpose. But if an employee comes to you and says, hey, I just gave birth, I now need to express breast milk in some fashion, I need that private place, you're gonna have to figure something else out if you've already replaced that office. But again, this doesn't have to necessarily be a permanent fixture at your place of employment, but you need to be able to put one in at all times. Again, this act actually went into effect January 1st of this year, so a bit older than the Pregnant Workers Fairness Act in terms of enforcement, but we're already starting to see these issues pop up, obviously, with it being almost a year old. What employers are subject to the PUMP Act? Essentially, any employer that's required to abide by the Fair Labor Standards Act must follow the PUMP Act. for those of you on the phone, that's almost every employer. That's 99.5% of employers must follow the Fair Labor Standards Act. The only real caveat here is that for employers who have fewer than 50 employees, they are not subject to the Pump Act if they can establish that there would be, that compliance with it would cause an undue hardship, similar to the Pregnant Workers Fairness Act under that standard. We have not encountered any of these situations yet for our clients where, setting aside another area, for this purpose would cause an undue hardship. I think it's gonna be a very hard standard to meet. I'm not aware of any courts having yet decided this issue, but if you have under 50 employees and you think, and an employee comes to you and says, hey, I need this private space, or you are aware that an employee is going to need a private space and you really having questions or issues about how to do that, definitely give your attorney a call so they can help walk you through whether that would truly constitute an undue hardship.
Brian, we do have a question.
Sure.
If our employees are not in our office daily, but are in other businesses, how is that handled?
That is a great question. So that is something you have to work out with that employee. I know we have a lot of clients, especially in healthcare, who have employees who travel. If you have under 50 employees, that might be the argument for an undue hardship. If you have over 50 employees, this might be a situation where we're needing to work with the location where they're performing services to see if there's an area that can be set aside. If that's not possible either, we're probably gonna have to have a conversation different than the today's presentation. We can have that conversation offline, but that's really what you're going to be looking at is if under 50, maybe that now constitutes an argument for undue hardship. But if over 50, we're probably going to have to be working with the client's locations about trying to get them a place that can be set aside and working with that employee, maybe, and without any undue pressure from the employer. Maybe that employee comes to you and says, no, hey, I'm fine doing this in my car. It doesn't bother me at all. That's not an issue. Problem solved. But if not, and they're asking for this place, then we're going to have to go through that process and go down that road. Again, what is an undue hardship for the purposes of the Pump Act only? It's determined by looking at the difficulty or expense of compliance for a specific employer in comparison to its size, financial resources, nature, and structure of its business. Again, if you had under 50, that with the question we just got asked, that might constitute an undue hardship. How to determine whether an employer has fewer than 50 employees. This is really, I'm going to sum up this slide for you very quickly. The number of employees you have is, for the purposes of the Pump Act, is the same number that you have for purposes of the Fair Labor Standards Act. So that includes all your full-time employees, all your part-time employees. It's those two numbers put together is what constitutes the number of employees you have for purposes of the Pump Act. So again, it's almost everyone who's working for you, except maybe independent contractors. So what counts as a private place? We briefly touched on this, but bathrooms do not count. Do not consider a bathroom to be a private place. The location must be functional for purposes of expressing breast milk, shielded from view, and free of intrusion from coworkers and the public. That's why, the ability to lock a door or something like that's going to really be a necessity. If the location is not solely dedicated to the nursing employee's use, it must be available when needed by the employee or another employee who need, for purposes of compliance. Remote employees also must be free from observation by any employer required computer camera or web conferencing platform. So again, this is a situation where if you have security monitoring systems at your place of employment or security cameras, this area has to be free from those devices. And I think also to that last point there, concerning the remote employees, if you have employees working from home who need to come on to a web camera, or they're required to be on a web camera 24/7, which I'm not aware of too many employers that do that. But if such requirement exists, again, they're going to need to be able to turn off that web camera or step away from that web camera for purposes of expressing breast milk. So quick question was raised earlier in the Pump Act by me that said, hey, do we have to pay employees who need to take this break time? And that's really going to depend on what your existing policies say. And I'm going to sum up this slide for you very easily right here. If employees are free to take 5, 10, 15-minute breaks that are paid, and this employee is able to express breast milk in, say, 15 minutes, then it's going to be paid. If they're free to take 15-minute paid breaks, then, but it's going to take them 30 minutes, then the 15 minutes is going to be paid. The second half of the 15 minutes, you could be unpaid. If employees do not have any paid breaks, then the time spent expressing breast milk would also be unpaid. So you're just going to follow your existing break time requirements and policies that you have in place. Some states have required paid break times. Therefore, you're going to pay for the time spent doing this. And again, it's got to be a reasonable time. You can't have a situation where employees can be able to sit in that room, all their entire shift, or otherwise, maybe try to game the system. I'm sure we haven't seen it yet, but I'm sure some employer across the country will see that at some point. In those cases, the time spent is intended to be reasonable. Again, so similar to the Pregnant Workers Fairness Act, the ADA, and any other federal employee statute, you can't retaliate against any employee who is seeking protections under this act. You can't discharge them, punish them. Again, and if you pay employees, when they're taking breaks, you can't not pay this employee. If you allow employees to go outside and smoke a cigarette for 10, 15 minutes and, you pay them for that, you're going to have to pay these employees as well. So you got to kind of treat that break as if you would treat any other break. What are the remedies for employers who violate the Pump Act? It would be, if you were to somehow not hire someone because, they said that you're going to need compliance with the Pump Act, they're going to need a place to express breast milk. Well, now you're going to have to actually employ them. Another possible remedy that the EEOC may require is reinstatement if you were to fire someone for exercising their rights. If you fail to promote somebody, obviously, because they exercise rights under the Pump Act, you're going to have to promote them. Things like that. All the basic remedies that exist under the EEOC for other forms of retaliation or discrimination. So that's really all I had for you today for those two acts. By and large, they're really kind of almost addendums, if you will, to existing statutes that you already have, such as the Pregnant Workers Fairness Act is very akin to the ADA. The Pump Act is going to be very akin to your existing break policies that you have. However, the change again here is the homework where this comes in for you all on the call, and for any other employer is going to be you have to have policies for these additional protections. You're going to have to make amendments to your handbook. You're going to have to make amendments to your existing break policy, or add on to your ADA policy if those policies are not otherwise in the handbook. So that's where that homework comes from you. If you have any questions while you're crafting those policies, or if you need any assistance with crafting those policies, definitely don't hesitate to contact us, and we can certainly assist you with that. I'll actually put my contact information here on the first slide. It is not. But I'll make sure that my contact information comes out when Sarah reissues this presentation. But again, that's really all I had for you all today. Unless anyone has any questions, I think you could use the chat box, or if you feel more comfortable, hopping on a microphone, you might be able to ask that way as well. Definitely hang out here for another minute or so. Do you see any other questions come in, Sarah?
Nope, no more questions.
Okay. Well, I hope I was able to answer all the questions that you may have had. If not, again, definitely feel free to give me a call, or your other trusted legal advisor a call. They could certainly help you with this. But that actually ends our webinar series. As I said, Sarah will be sending out this presentation as well for you all to reference back to. And we look forward to engaging in our next employment seminar or webinar series, maybe next year, when additional employment laws come, such as the changes to the Fair Labor Standards Act. We're going to have a lot of questions and issues that come up when that occurs. But I look forward to presenting with you all again next time. Thanks.